Bharti filed an application to the court. They filed two applications. In one application, they filed a motion of appeal. So they would like to appeal the decision of the court, which is their prerogative. I'm very happy to see them there. I'm always excited to see our legal systems tested and made to work. This is a big case. So they have appealed, or rather they have issued a notice of appeal. But they have also issued an application for a stay of execution. In other words, they're like an injunction so that we cannot proceed to effect the order that's been granted. Now, we had written to them after the order was granted to say, look, we're a shareholder, so release to us the minutes of the meetings of the company so we can look at all the resolutions that have been issued, which are now in contempt of court. So we need to ensure that working with you as a shareholder, we look at each of these resolutions carefully and see how we can proceed. So we've been as reasonable as one can be because we're a shareholder. Obviously, once they decided to appeal, we saw a statement outlining the reasons of their appeal. And then I've had many calls from the media to say, what are the implications to Bharti of this ruling? The implications are outlined by them in their notice, their application to the court for a stay of execution. I'm going to read you the application made by Bharti, Section 5.1 of their application to the court, which they made after the ruling on the 26th of January. They said to the judge, the judgment, particularly the nullification of the decisions held at meetings at which the plaintiff, meaning us, was not invited, will adversely affect the operations of the applicant, meaning Bharti, and its corporate existence. The effect of the judgment, if it is not suspended, will have an impact on a number of key corporate actions taken by the applicant and will unravel and cause the applicant incalculable loss. That is what Bharti said to the court in their application before a commissioner of oaths signed on the 26th of January, 2 days after the ruling. But a week later, they issued a statement to the media, which bears their insignia, saying that we want you to know that this judgment has no impact whatsoever on our operations. These appear to me to be two totally contradictory positions.